know how to do that.
It looks like you are.
Alrighty then. And then, again, we have a whole host of individuals in the attendee room. I can let them in now. I can let them in as you would like to invite them. Your discretion.
Why don't we let the folks who are knowledgeable resources come and join us, and we'll introduce ourselves here around the table, as it were, and then they can introduce themselves when they provide us with comments and information. So I'll begin. My name is Ann Matlack. I chair the State and Local Government Committee. I represent House District 92, which is in the Mid-Coast area, including Cushing, Thomaston, South Thomaston, St. George, Matinicus, Prehaven, and the Muscle Ridge Islands. Representative Copeland.
Good afternoon, everyone. My name is Lynn Copeland, and I represent House District 14, which is downtown and coastal Saco. I'm also a member of the State and Local Government Committee.
Thank you. Senator Claxton.
Thank you, Madam Chair. My name is Ned Claxton, and I'm honored to represent the folks in Auburn, Minot, Mechanic Falls, Poland, and New Gloucester that constitute Senate District 20.
Thank you. Representative Downs.
Good afternoon. I'm Representative Kathy Downs. I represent District 130, which is Bucksport and Arlington, and also I'm on the State and Local Committee.
Thank you. And Representative Toole.
Thank you, Madam Chair. I'm Will Toole. I represent the Machias area, plus Lubec and Eastport, and I'm the House Republican lead on state and local government.
Thank you very much. I appreciate you all participating on this subcommittee. Today we're going to have, we have several people who will be joining us at different times to talk about this issue with us and to provide information, their perspectives and so forth. But I'll leave it to Lynn to bring us up to date on what we talked about at our first meeting and where we might be headed. We had asked for some materials. She has provided some of those to us. And will anybody has any questions about the materials she provided, please let her know. Lynn.
Thank you, Madam Chair. And just as a note, Roberta was here and she disappeared. But if she's listening after I do my presentation, I will try and find her again. So what I sent out to you was some material, two categories. One category was specific information that the committee had expressed interest in, that you wanted more information on. And the first categories are I'm just going to go through and just kind of remind some of you of what the law says in specific areas, very briefly, in a cursory way, but I just wanted to make sure everyone had the same amount of information and understanding on areas that I think are going to be helpful to where you may be headed. And as I said, the first meeting, it's somewhat of a shot in the dark because it's a very complicated issue. So please stop me, ask for more things if this isn't working. And I'm not going to screen share unless you would like me to. So the first
you did send out a handout to everybody yes. Earlier today with all this material. So yes, please. Thank you.
Yes. And for those who are listening, the materials are posted on the subcommittee's webpage. So the first thing I just want to clarify is that there are two legal causes of actions, two avenues to use if a public easement or the discontinued road is damaged. There is a section of the criminal code in Title 17, which makes it a Class E crime to operate a motor vehicle on forest, farmland, public easement, that if it in fact damages the road or the public easement, that's a Class E crime. And a motor vehicle, so this is operating a motor vehicle that damages the road or the public easement, is a Class E crime. And a motor vehicle in this statute of the criminal code includes ATVs, does not include snowmobiles. The other cause of action would be the property owner, the abutting property owner in Title 23. And again, this is in the material I sent you. If there is damage to a discontinued or abandoned road, the the abutting property owner can file a lawsuit in Superior Court. And if they win, they can get awarded attorney's fees. So as most of you know, that provision that if you win, you get attorney's fees is really designed to help people who may not otherwise have a lot of money to sue. That's kind of the, you can go forward with a lawsuit because if you have a good legitimate claim, your lawyers are going to be paid for. So that is the current statute in Title 23, and that's relatively new, but it does allow for damages and for attorney's fees. The next kind of topic I wanted to go through, I'm just making sure I'm going in order of my summary sheet. Well, I'm not, but well, I am. So there are some statutes out there that, and you've heard this before, that require the seller of whether it's residential or non-residential property. So the seller must disclose whether the property is accessible by a public way, and if it's not a public way, they have to disclose who is responsible for the maintenance of the access. So that is also a relatively new statute, applies to both commercial or non-residential and residential. So in addition to how do you get to your property, you have to disclose who's responsible for maintenance. And that is if it's not a public way. The other kind of category I wanted to go through, and this is on attachment B, is what are municipalities' rights and obligations? And again, this is just a broad brush. When it comes to a public easement, a discontinued road. So they have an obligation to prevent storm runoff if it's near a great pond. So that's in the statute that they have an obligation, that's in Title 23, to appropriate funds to repair a private road if it is going to cause runoff into a great pond. So that's an obligation on municipalities to protect great ponds. It allows them to spend money on private ways.
I just got on, so I think.
Hello, Roberta.
Okay, thank you.
So the next statute that I just want to bring to your attention is the statute also in Title 23 and on attachment B that allows the inhabitants to vote to spend money on private ways for fire and police protection. So again, so that would be spending money to plow in front of a fire truck or a EMS truck. That is allowed. The inhabitants of the town can decide to allow use of funds for fire and police protection. Now, again, like the first one applied to private roads. This one applies to private ways. It's not exactly what we're talking about because we're talking about discontinued roads. And I want to acknowledge that some of these are not exactly, they don't use the word discontinued road, but I think that it's that in most cases, it's safe to say, that municipalities can also do these things if it's a discontinued road. So spending money on a discontinued road for fire and safety, it's not in that statute I cited, but I can't imagine that if it's for fire and safety protection, for example, a plow truck, that would run into a problem. Again, there's another statute that talks about the DOT and municipalities' ability to restrict weight and the passage of some certain vehicles on public ways. And I believe that some of the MMA material that was given to you may have included information that, and Rebecca is here and she's going to correct me when I am wrong. I know I can count on her for that, and you can count on her for that. That most municipalities believe that statute that allows them, let me rephrase that the statute that allows them to restrict weights or certain vehicles could probably be applied to the public easements that they retain. If we want to have clarification on that, that may be an issue for further discussion. I also would say that municipalities have the ability to close roads. Now, again, roads temporarily, but I don't think it would be a stretch, and it could be clarified if it needs to be, that municipalities could close a public easement, the use by the public on these discontinued roads. So I'm sharing those. Again, they're not right on point. They don't talk about discontinued roads, but I think they raise an issue that you may want to discuss further about what can municipalities do right now to minimize damage to discontinued roads for that public easement use. What are the tools they already have? And I believe that they also have the ability to restrict, to specifically say certain types of use are not allowed. They're not allowed at different times of year, and the like. So there are some tools in the municipality's toolbox. The next, let me pause. Let me tell you what the next items are going to be. So then if you have questions, I'm putting Rebecca up next, because as you recall, MMA was doing a survey on this issue, and she may have some updated information for us on what the municipalities have, how they've responded to MMA. I also have some information on road inventories and minimum maintenance roads, because that was an issue. And then I have a couple other matters to bring up. But on the ones I've discussed now, are there any questions on those?
Representative Copeland?
Thank you, Madam Chair. We talked about this disclosure before, but just for clarification again, is that only when there's a realtor or an attorney involved?
I'm not sure. I would think that private individuals can also use those disclosure forms.
But if they don't, then how is it handled in terms of them being on notice? That was something that we talked about in the committee.
Well, let me see if it's on this sheet of paper that I have, and let me make a note to perhaps look it up to clarify for you while Ms. Graham is talking. But I do not know if it's per sale in every situation. That's the way I initially read it, but let me confirm that.
Right, because
I can sort of chime in. My daughter recently bought a house directly from the seller, and while we both used attorneys, both sides used attorneys, there was that form that was completed. It's just a photocopied form that you just answer a couple of simple questions with regard to the road, who maintains it, who plows it, whose responsibility is it, is there a road association, and so forth. So, if it's between two family members, two friends, or whatever, I don't know, but I think you would probably have to have some sort of legal advice with regard to selling a piece of property. So I can't imagine that you wouldn't have that form prepared.
Well, there are a lot of people who just do it from family member or neighbor or whatever.
Mhm.
And that's why in committee we discussed, whether there was something that could be filed in the registry, whether there could be a notation on a real estate transfer tax form, which is probably not the best place, but it's, it's there. I don't know. So I would like to find out for sure, because that,
discussing whether or not it's a private road. Is that what you're, or there's a public easement on a private road?
Yes.
Okay. I may go look at the paperwork and see. Senator Claxton, you had your hand up? You're all set. Okay. Ms. Manter, you have your hand up?
Yes, I'm not putting my video on because it's not working right. It's making my face all fractured. But to answer your question, when there's a private sale, the private individual may not be aware of the new law about disclosure. And even if they are aware of it, they can simply say unknown, and that gets them away, gets them out of the requirement to disclose it. I have had one very recent complaint from someone who just bought a piece of property a month or two ago, I believe. He had title insurance. He had the disclosure form, which said it was unknown. He was told that there was shared maintenance of the road by the people who used it for access. But it turns out that most of the land is either owned by a logging company or is actually owned by the town and is public land. And neither one of them has any inclination to contribute to maintenance. He's also found out what wasn't disclosed was that it's an ATV trail, and the use by ATVs is tearing up the road. He is naturally very upset. He's going back after the title insurance company, and it is a huge mess. So that's just one example of what can happen even with the disclosure law in place.
Thank you. Ms. Graham, welcome to the meeting. Thank you for being with us today.
Thank you for having me. I might be able to add to that. So under Title 33, there is a full list of property disclosures, and the caveat is the seller. So it is not contingent upon a real estate agent. It is the seller that has to disclose that full length. And at the very end of that is the road disclosure piece that was added to that list. So and the Title 29A definitions of what that is. So that is required, whether it's a private sale or whether it is a real estate facilitated sale.
Thank you.
Thank you. Do you know if they mention, I can look it up once I get off of here, but do you know whether public easements are listed as something that's disclosable?
Right now, it defines the public way in Title 29 as to what that is. And then any means other than a public way, in which case the seller shall disclose information about who is responsible for the maintenance of the means of access, including any responsible road association, if known by the seller. So they could put unknown, but I think that, you know, again, that's the buyer should be interrogating that. Most people know who maintains their road.
Gotcha. Thank you. Representative Toole.
Yes, thank you, Madam Chair. I wondered what is the penalty for not disclosing? And I probably should know it, but I'm curious to find out what the penalty for not disclosing. Does it vary by area? Does it vary by topic? Does anybody, I guess my question, I guess it would be to Ms. Graham or anybody else, if they would know what the penalty is.
I don't. I'm
I
willing
don't
to
know
bet
about
that's-
the penalty, but it seems to me that it would be a civil matter. And the courts are set up to handle that.
Yeah.
Okay.
There's also the ability to supplementally disclose, but it looks like that it would be civil, and it doesn't necessarily, if it's inaccurate, it doesn't constitute a violation. So I think it definitely would fall under civil. I don't know that there's a robust enforcement mechanism there.
Gotcha. Thank you.
And that I would think would be, that's whether that's something we address, I would think that would be a problem to that, you know, what incentive do people really have other than doing the right thing? Not that people don't want to do the right thing, but sometimes things do slip through the cracks. And I'm not saying it should be an A, B, C, or D offense, but you know, we've got other parts of this that are Class E or as you say, civil. And I think that would be, I think it would be good to know what options people have there for recourse.
Thank you. Lynn?
I was just gonna, I think, support what others have said. And the question that you're asking, I think a real estate attorney may be the best person to answer that. It sounds to me like a civil action for some sort of fraud. And I can follow up and have a real estate attorney. There have been other real estate attorneys who participated in these subgroups in the past who may be willing to answer that. But I do think it is a civil matter. And adding a provision in the statute identifying a penalty is always an option.
Okay, Lynn,
I
Representative
bel-
Copeland, yeah, the other Lynn.
Thank you. Thank you. I appreciate it. Title insurance. This is what title insurance is for. All of these kind of things. So I don't know if the state needs to be, I don't know. I don't know if I feel comfortable putting another a restrictive something on the law when there's already all these remedies, civil and,
Mhm.
you know, insurance and
Yeah.
So that's my take.
Okay, thank you. Lynn, Ms. Caswell, next topic for discussion. Any further discussions on this in this area? Okay, Lynn?
Thank you, Madam Chair. So I think perhaps now, Rebecca, if you have some information you wanted to share on what you may have learned from the survey of the municipalities, and perhaps you can remind us again what it involved.
Sure. Thank you, Lynn, Representative Matlack, Senator Claxton, and distinguished members here. My name is Rebecca Graham, and I'm a legislative advocate with Maine Municipal Association. So let me back up. Sorry, I should have started with that. MMA has been involved in a number of these stakeholder groups across a wide spectrum of desired statutory change. So we did a really comprehensive survey that we sent out to members rather than hitting them on a regular basis. It's kind of a big lift. We didn't know how it was going to fall. However, we got pretty good response back, almost 200 responses to this survey. And the parts that didn't pertain to communities, they often didn't have to actually answer. So, Lynn, is it okay if I share my screen so that I can show you that? Or
Certainly. Certainly. I mean, technically, Lynn would be able to answer that, but I'm happy to see your survey. I'm happy to see your survey.
I was gonna defer to you, Representative, as you are the chair.
Thank you.
let me know if you are seeing my screen now.
Yes, discontinued roads.
Okay, great. I had issues with this in the Teams earlier today. So we asked a bunch of questions for the folks that responded, and if they hit or didn't apply, then they didn't have to dive down deeper, trying to make it a little less onerous. So I thought I would start just by talking about easements and the ways in which easements can be and are created within the municipal field, and just kind of a brief list and history of it. So many of the easements prior to 1976 were automatic. Municipalities might not even be aware that they own them, and often it's a pretty laborious process for them to find out. And there are a number of ways that those public easements are held, and they can be held by the state, the county, or the town. And they range from just winter roads that either only exist in the winter and don't exist at another time, bridle paths, trails, even public landings, and specific recreational easements. Then, of course, you have the townways, and then you have private ways as well. Prior to 1976, they were all taken by automatic fee simple. After that, they were taken by eminent domain principles, and market share came in there. Representative Copeland, I'm sorry, did you have a question for me?
Well, just to comment, I'm looking at this. I zoom on my iPad and it's very small. If you could make it a full size slide, I'd be able to see it better. I work on my computer screens over here, but
I know it's full size on mine. So let me see how. Are you looking at something that has?
It says easements 101.
Yes. Is it? Are you seeing any other screen, or just seeing that one slide?
I see the discontinuance of easement as well.
You do. Okay. Let me take it out of there then. Let's see.
I apologize, but I think that
No. It's important for you. How's that? Is that a little?
No, not yet.
didn't change.
It
Oh,
didn't.
there we
There
go.
it is.
Perfect. Thank you so
Okay.
much.
Awesome. So
Apologize
sorry.
for messing with the flow here.
Thank you very much. There's also common law easements. and those primarily go to the pursuit of public trust doctrine activities. So navigatable waters, great ponds, those easements are retained. Access to cemeteries, and Maine has a tremendous amount of cemeteries, as this committee knows very well, that are not even within, necessarily the municipal spectrum of knowledge. Lateral support is between communities. Drainage, as Lynn had mentioned earlier, and then basic covenants. There's also kind of the same, I'm trying to think of the name of the principle, but you can do an easement by prescription in the same way that you can have squatters' rights, basically. You must prove that an easement had been used, even if it's on a private piece of property, continuously for 20 years, and it has to be open and hostile. And then it is presumed that you are allowed to use that easement for that continued access. So the ways in which you can discontinue an easement that the public has expressed a clear desire to terminate that access. Currently, you can petition the termination of an easement to that community. Also, the statute of limitations, this pertains to paper roads, basically, that they're automatically vacated unless the municipality has expressed an interest in maintaining that. Usually that's to retain abutter access to landlocked properties that may have been created out of subdivisions. Since 1990, the installment of public utilities easements is not available unless it is explicitly stated. So that needs to be either maintained through a public easement. That's kind of the easier way to do that. Or if that easement is discontinued by the municipality, then there has to be a replacement for the installment of public utilities across that privately owned road. So paper streets before 1987 are deemed vacated. And 15 years after the roads have been placed on record, unless the municipality decides to accept them. And that's also key too, because this does not happen frequently. This is very, very rare. And I think you may have received a letter from a municipal official about that. But if not, I'll definitely make sure that that gets to you. There have been maybe 5 within this particular region over the past 20 years. And that is, so it is on the scope of this is really, really low. So the questions that we asked were, are you aware of any discontinued or abandoned roads in your community that have retained a public easement, where they haven't actively been part of the process to either divulge of the, or to dissolve the public easement, or even if they are aware of any abandoned roads or discontinued roads within their community. Most of the individuals that got to this area, over 60% of them did not know that they had abandoned, or did not know if they did have abandoned roads or discontinued roads in their community. And then 40% of them did. So then we moved on for that 40% that did, the reasons for keeping those easements on those public, on those discontinued roads. There was a significant portion of them that didn't know. Many of them were inherited from the state / county road turnback program that happened in the 70s. Many of them, a larger proportion of them, were access to specific natural resources. Some of them were harvesting from the shoreland along tidal waters, and also heritage industries. So access to harvesting, basically. And the biggest overwhelming reason was access for adjacent landowner or disputes that felt like the municipal easement was the only way that they couldn't divulge of it. So we then asked if the municipality used those easements for activities that were specific municipally oriented or known of. And a very small portion of municipalities actually used those easements for municipal activities. The largest portion of them just kept to maintain kind of good neighborhood, good relations piece, or access to those resources. And then we wanted to know what types of complaints they would receive about discontinued or abandoned roads. And not insignificantly, the two key comments that we found within this kind of open text area that we asked for were damage to the road and neighborhood disputes, usually which were intertwined. I can't see the notes, unfortunately, but I had notes in there with some specific comments that municipal officials had said. And a lot of it was, you'll have a single landowner that either restricts or feels as though that they have primary ownership of that right of way, and therefore restricts abutting neighbors accessing it, or they encroach upon that that way and try to restrict the activity. So the public easement piece is kind of the tool of last resort that just maintains connections in those instances. And damage to the road, of course, was the number of complaints. Also proportionality for the users that actually used those ways in relation to the amount that it would cost to maintain it. So a number of them said there's only 2 residents. That's an extremely long road. They've made a choice that to live there. It's been that way for quite some time. So it just wouldn't proportionally be feasible for the community to actually maintain that road for two residents. Some of that, another vast majority was that people don't receive any complaints about these public easements. And again, the newest probably comment that you're getting is that newcomers who have purchased that property are really unsure of the history and unsure of how Maine both funds their roads, the whole process for road funding, and has different expectations from where they came from. So we asked municipalities whether or not they would welcome restrictions on activities on easements. And most of them were really not sure because they really wanted to understand why that might be necessary and were concerned about unintended consequences further on down the road. So we specifically asked with a budding property owner agreement. And I think that also kind of skewed that, because I think that the vast majority of municipalities felt as though that the abutting owner agreement piece was a really big lift. And that is why they had often maintained these easements and not the maintenance as it was. And then the rest of the comments were split between yes and no. So that is the extent of the survey results. And hopefully that may have answered some of your questions from that municipal view, just kind of generically. But I'm happy to take any questions if you have any.
Thank you. Representative Toole.
Thank you, Madam Chair. And I have a couple, but I mean, there's a lot to process there, but I think one that comes up first on the first question was people weren't sure whether there was or there wasn't an easement, or what the status of whatever the case may be there. Did they give any indications as to did you try to drill into that a little more to figure out why that was the case? Is it just a general lack of knowledge? Is it a lack of resources from the state? Is it people just doing private sales? It could be any number of things. I'm curious to find out what people don't know that they may or may not need to know.
Representative Malik, may I answer?
Certainly, if you could, please.
Sure. Thank you, Representative Toole, for that answer. There was an individual that reached out to me that is in the midst, or actually kind of the fallout of exactly why folks don't understand or don't know that they have these public easements in a community in Western Maine. And it was an extremely laborious process. And it was basically a legal title review of this road to figure out if there was a public easement. And it came up with road constructions over what the town had known and expected was a private road. And then new residents came in and they wanted a specific level of care, but they also wanted access. They wanted to bury some utilities, and the utility company was unwilling to do that without getting some sort of permission. So it was litigated. The county had actually gone through and oversaw and maintained what the town had. Like, this is this is public easements, you know, we did retain a public easement over that property. We're not responsible for maintaining it. And you're responsible for dealing with the burying of that. That's not necessarily a municipal expense. That's something that you've chosen as a neighborhood through your private road. The easement facilitates that for happening, and it facilitates the company for being able to do that, where it's not explicitly in their private road charter. So that's how that played out. And it cost the town about $15,000 in legal fees, and they prevailed, but they were required to go through this process, which is equivalent to doing a history of a piece of land to understand if they actually did have the easement. It's not something, because of the way in which they are constructed and because of the way in which they've been passed on to municipalities, that it's one of those things you have to parse through. So it's not automatically known. It is automatically known when you've discontinued a road or when there's been a new development. So where that has happened, and I think Glenburn is probably a key example of that, municipalities have been really explicit with residents that they have no responsibility, but all in building permits. So if you choose to build on this piece of property where there is one for sale, you have no maintenance from the town, and that's on you. And here are your rights to do the road association, of which, you know, they're still waiting for that particular community because there are holdouts from that community to be able to get onto that. So the short answer is you don't know what you don't know until there's an issue.
Right.
And because of that first list that I showed with the numbers and ways in which easements are created, it's really hard to get a snapshot without doing detailed history of that whole road creation.
And that really is one of the challenges with this whole topic is you don't know what you don't know. And I have yet, as many years as I've been on the committee or the subcommittees even, I have yet to be able to define in 60 seconds or less what constitutes the quick and easy way to explain a situation about this community or that community or what they may be in. And I think that's where some of why there's so much confusion, why there's so much tension, is because there is a lot of unknown, and it's not all the same thing. But I wonder I don't know how you go about figuring that out without where it is uneven across the board, if that makes any sense.
Okay, thank you. You're absolutely right. I mean, there's so many variables involved here, and because so much of it is pre-computerized, it requires digging through paperwork, and sometimes that paperwork is not available, and sometimes it's handwritten. So there's all sorts of different ways of trying to find things, and it can be quite an endeavor. Thank you very much for your presentation. I really appreciate the information you provided to us. Ms. Caswell.
Thank you, Madam Chair. So as a segue, we are going to go talk about road inventories. And I just want to let Maria Jakes from Maine 911 and Pete Coughlin from Maine DOT know that this segment, I thought we could take a few minutes. You did receive some information from Pete that was online. It was an example of, I believe, a map and then an inventory. And then Maria is here to answer any questions you may have about the Maine 911. My understanding of the difference is Maine 911 has all the roads. They just don't have the legal identity because their focus is getting emergency vehicles. And that Maine DOT has lists of roads that municipalities have said are within their purview, and therefore they're receiving funding. But again, Ms. Jakes and Mr. Coughlin are here if you have questions on either Maine 911 or the Maine DOT inventory.
Thank you very much. Who should go first? Mr. Coughlin, Ms. Jakes?
Sure, I can go first if you want. Hi, Maria.
Okay, so you're going to be just a voice for us today?
Yeah, for some reason, my video, my little portable plug-in video here just isn't working again. So I
Oh,
got to
no
get a
worries.
new one or something.
Okay,
So good afternoon, everybody. It's good to be here again. I'm just going to kind of review what I did at the last one. Maine DOT has for decades kept track of public road inventory. In other words, roads that are maintained. And I emphasize that are town maintained, and most of those are year round. Many towns maintain roads seasonally, either in the winter only or the summer only. And this all goes toward providing the basis for the local road assistance payments that go to every town. Because that is $21 million a year of DOT's budget, which is 9% of the highway budget. And that gets allocated strictly by the inventory that we have in the system. So in other words, if the mileage is correct, the dollars are correct. And the opposite of that too. So I make quite an effort. We used to do this on a rotation up until about 10 years ago, but then I started working with Maria and other folks at 911 because there were 2 state agencies tracking inventory in the state. So we do this together now. So for instance, last week I did 2 inventories, and I take those results. I meet with each town, spend an hour or so with them. We go over all the roads that are maintained, and then I send that to our mapping people, and I send it over to the folks that work with Maria, and we update both systems. So again, I'm just concentrating on what they maintain, and I state that right in the beginning. All I'm interested in is what you maintain. And the implication there is that if you're maintaining it with public dollars, then it's probably a town way, a legal town way, or it's a public easement. And I just leave it at that. I don't want to know, I don't have to know the legal status of the road. It's just, what do you maintain? So I guess I'll leave it right there, and Maria can pipe in from their perspective because they track all roads in the state, public or private.
Good
thank you,
afternoon.
sir. Go ahead.
Oh, I'm sorry. Representative Matlock, Senator Claxton, and other distinguished members of the committee. My name is Maria Jakes, and I'm Director of the Emergency Services Communications Bureau, and we're housed under the Public Utilities Commission at the present time. At one time, we were part of public safety, but it's been many years. So I have worked in addressing actually since I came to the Bureau over 20 years ago. And for 911 purposes, we track all public or private roads, but we don't track the legal status of that. So we are concerned about getting emergency response to every structure or every resident in the state. So we have Pete's system that only cares about public roads. We care about both. Now I want to put one caveat. You said we track all of the roads. Well, that's our goal, but participation in Maine 911's addressing program is voluntary for municipalities. So to the degree of the effort that is put into it by a town is that accurate. But we get very good response from our communities. There's a large changeover of addressing officers for each municipality. We spend a lot of time retraining folks. And some of that institutional knowledge goes away every time, you change people that are responsible, unfortunately. And that's something that happens, I'm sure, in many areas of local government. And many of those people are volunteers. So they may not be in the office and hearing all the chatter that might actually inform them of various things. So we have a lot of volunteers. So we have a process, electronic process, a tool that I think there was a link on that page, that fact sheet that Lynn sent out, that addressing officers can log in and tell us all kinds of things about new roads or changes in roads. And there is a spot there that they can check public or private, but really we don't care why it is private. And in fact, our recommended addressing standard suggests that any driveway that has 2 or more residents on it be named. And that constitutes a private way. Please don't take anything like as a legal term. If I say something, just jump on that as legal. It constitutes it as a private road from our perspective. But we rely on the towns to tell us that. Pete and my GIS staff did a reconciliation of what he had for public roads versus what we had a few years back, just so that our lists were in sync. We do share information we get the other way with Pete, so that we are not duplicating efforts in actually hopefully saving the town some work. So there is no abandoned road information or other classes information regarding easements, because the main goal for us is just getting emergency services to the people that need it. And I entertain any questions you have.
Thank you. Does anybody have any questions for Ms. Jakes? Representative Toole.
Yes, thank you, Madam Chair, and thank you, Ms. Jakes. That was very informative, as was Pete's, Mr. Coughlin's comments as well. And I think, you know, we can talk about a process around a public easement or public-private or doing away or allowing towns to do away with, but we really don't have a solid base of the status of these roads. And I know what you're dealing with as 911 officers filtering information back. You know, I know in our town in East Machias, we had, that was a 1 day a week thing. If you know, it was a voluntary thing. That's a lot of work for one person. And the information you have, it must be difficult to tease it out. And I guess my question would be for either or both of you is just how hard is it to get all of that information and get it together? And would legal status of a road be something that either you or somebody else in the state or even the realtor, whoever, may be interested in having? Because it seems like if we have all the roads, or most of them, it would be nice to be able for somebody to be able to go online and look and see what it is. I know that's a loaded question, and I'm not sure this bill would solve that, but it just seems like that's a missing piece.
So Representative Toole, I'll answer that as best I can here. You know, DOT is responsible for paying local road assistance based on public roads that are maintained. So we're not going to undertake any process where we're going to have towns verify whether they're public or private. The legal status is not of interest to us. Plus, I don't have staff to do that anyway. But I think it's fair to say that probably most roads that a town maintains are probably legal townways anyway. You know, it's not often you find many towns. I mean, there's certain pockets of the state that have a large number of summer only or winter only maintained roads, and those may be easements. But I've never really got into I've never asked the detailed question of that. So it would be quite an undertaking.
Yeah, it would. But, and with that, I guess I I wonder if it would seem like, though, whether it's not DOT or 911 per se, but it would seem like there is somebody in the state that would want that information or could benefit by it. And I don't know, again, I don't know if this is the time and the place to gather that or how much doing such a thing would cost. But it seems like that's one of the big issues that's got to be to have a long-term approach to this. I'm not just saying a Band-Aid or short-term. That's gotta be part of the mix, is knowing what we have and what the status of it is.
Right.
Yes, I would just add to what Pete said is, my staff struggles to get the information it needs already out of municipalities. And from the perspective of dedicated revenue to the amount of effort that we would need to put into this, I don't think that might not constitute an appropriate use of 911 dollars if there's not a direct tie to 911. I hear you. I spent many years on the planning board. I understand, people buy property, they have no idea that they're not going to have their road maintained. I get it. I've heard it for years. And in fact, the town I lived in started, whether they had the authority or not, requiring subdivisions to have road associations attached to them, new subdivisions, because it became such a problem. But anyway, so that would be our take on it. And even the limited information we ask of addressing officers, we frequently are chasing them because they didn't completely fill out a form. So having said that, I very much, to all the towns out there that are listening to this, I appreciate all their hard work in making our 911 system the great one it is today.
And I would agree with that. I know, coming from a small town, the last thing towns need is more paperwork and more stuff to throw on. I really do. But, we do see we have some information, but I'm just thinking in terms of the challenge of this bill and how to move forward with it in a meaningful way is gathering information so that the issue actually gets resolved long-term, because we can tinker with public easement law or play around there, but if we don't know what we're getting into, we're getting into a powder keg and having a lot of unintended consequences, as Ms. Graham stated earlier. So that's the challenge, and it really is. It's no ill reflection on any one of these towns, and I hope, or anyone at the state for that matter.
Thank you. Senator Claxton?
Yeah, a couple things. Thank you, Madam Chair. Of Mr. Coughlin, do I understand that the state compensates only for roads that are maintained year round, so that winter and summer roads are not covered in that?
No, it's both of them. It's the rate for local road assistance for year-round maintenance is $1,200 a mile, and the seasonal, whether it's summer or winter, is half of that.
Okay. All right. Thank you. So to get to Representative Toole's point, who has an aligned interest with wanting to expand the database that 911 has to provide reliable information to the municipalities about the status of their roads? Because $15,000 to defend one case would make a big difference to a lot of these municipalities if some of those things could be avoided. That's one point. And my other concern is I at least want to make sure that we're not still digging the hole deeper for the various issues that have been surfaced so far today. I'd like to see that we made at least some progress in stopping to dig holes deeper for these ongoing issues. We got a letter today from a woman who bought a property. I'd be interested to see how these rules or what we've talked about so far would apply to her. I didn't have a chance to read the whole thing. And I'd also like to hear 911 reference, but then there's the Glenburn Road. And I understood that to be almost impassable at times. So I think we need to have the conversation at a level of understanding and then start to try and apply it in various places and see how it works, or what the impact of that is. Just a summary of where my head is right now, because it's still spinning.
Right. Yeah. Ms. Manter?
Yes, I've been kind of collecting thoughts here and trying to put together some concise answer. In regard to Representative Toole's question of whether there was an easy way to figure out how to find the status of the road in 60 seconds or less. In the dozens of people who have gotten in touch with me in the last few months questioning the status of a road, I have had one that I actually was able to answer in not much more than 60 seconds. And I can thank Pete Coughlin for that, because what I was able to do was I went on the main DOT map viewer, clicked on the road she was asking about. That was discontinued by the county in such and such year. Here's the book and page number where you can go to the Registry of Deeds and find out what they said. That was the one that I've had that was that easy. Most of them, it takes a whole lot more than 60 seconds. It often requires going to the state library and looking up the town reports and just going through every town report that I can find that might be in the year range of when the road might have been discontinued, and see if I can find a town discontinuance order, which will say whether or not an easement was kept on the road. A couple of offers that I've made before. One was that I would be willing to give a seminar for towns on how to research these things, so that maybe they can get together a volunteer committee to go out and track down each of these roads and try to find out what the status was. We did that in the town of Fayette a number of years ago, and we're able to identify most of the town roads. There were a few that were loose ends, but most of them we were able to figure out what they were. But I think if we're going to do something like that, we need to learn from what Vermont did several years ago. They got together volunteer committees, only they didn't give them much training. They just said, go out and comb the woods for roads. And these volunteers often came back with traces of roads that maybe never had been a town road or a county road. They were just old woods roads. But what did come out of that was good was that the way the Vermont law was worded, they had a certain number of years in which to classify all of these roads that they had found. And they could classify them as either being state roads, town roads, whatever, down to trail, a trail being similar to what we have as public easements. That is, that they're still open to public use, but nobody's responsible for maintaining them. And then there were unclassified roads. And the unclassified roads, after a certain number of years, if they hadn't been classified even as a trail, they were deemed to be extinguished. And my thought, and I made the suggestion to the legislature a number of years ago, was to have each town start with the DOT list, or maybe now that we also have the E911 list available, if they start with those two. And if they could send out with the annual tax bills, so that it doesn't require an extra mailing, send out a list of the roads the town knows they have. A list of the roads the town knows are maintained by the public, or if they can include the 911 information, they could also include roads that they recognize as being private roads. And make it known to all the citizens, if you know of a road that is not on this list, then you have a certain time limit within to notify us. And if we look at it and say, oh, yes, that one is one of our roads that was just omitted, it was an oversight, they can add it to the list. If they don't know the status of the road, then they have a certain time limit within to have a hearing, examine the evidence, and try to figure out what the disputed road is. Chances are they're not going to have, well, say in the town of Fayette, there are 21 public easements that I know of. Chances are they're not going to have people from all 21 public easements come and say, oh, that should be a road. There might be, I'm going to guess maybe one or two, maybe three, where people say, oh, but we think this should be a public road. And then they're going to have to track down those few, and those others that don't get addressed, that nobody complains about, those should be extinguished. One thing to bear in mind in that case is that often there are old existing private rights of access that were there before the townway was there, or before the county way was there. For example, the road that I'm on was laid out by Lincoln County, Massachusetts in 1791 as a 4-rod wide county road. It was road LC 2-30-2, and it went from Wayne all the way up to through Fayette to Chesterville. But if you look at the layout, it was very clear that they were laying it out over things that were already there. And one of the ways that you can be sure of that is that although the countyway was laid out at 4 rods wide, there are stone walls at 3 rods wide. So obviously there was something there before the county way was laid out. And in cases like that, it could be said that those private rights that were there before the road became a public road are still private rights of property access. That could solve a lot of these problems. So those are just some of the thoughts that I had. I have some other thoughts, but I won't burden you with those then. And by the way, I realized that I didn't introduce myself at the beginning in case there's anyone who's listening in here. My name is Roberta Manter. I'm from Fayette, and I'm the founder of Maine Roadways, which is an acronym for Residents and Owners on Abandoned and Discontinued Ways. And you can find me online if you just Google Discontinued Roads Maine. I'm usually the first thing that pops up. Thank you.
Thank you, Ms. Mentor. Ms. Graham.
Thank you, Representative Matlock, and thank you, Ms. Mantar. I would agree that that sounds like it's easy, but I think we do need to look at proportionality, because in reality, it takes an excruciating amount of time to determine the legal status of a road. So simply asking does not determine whether or not that town actually has authority on that road. So that cuts both ways, but it's also going to be a tremendous burden on what are the municipalities that have the least amount of staff, the least amount of volunteers, and are struggling already just to keep their town offices going, because these are largely rural areas where these roads exist and continue to exist. So I think that it would be really beneficial to think about the proportionality of this problem in relationship to the scale of the solution that Ms. Manter is asking. It would be great if that were the solution. However, legal status of roads tends to require a very deep research project, mini PhDs. And I can speak to this because I had abandoned roads that were involved in my archaeology thesis. And that was a three-year project. And these were things that were not on the municipal radar. And it took not just going to the town, not just going to the state library to look through town records, but also deed registries, both here in the Massachusetts archives, because not everything is available and not everything is readable on the microfiche as well. So there is a lot more involved in determining the legal status of a road than simply asking what folks think or what folks might know within that particular history. You can get clues, they can point you to that area, but the legal status requires that whole deep legal dive on that.
Thank you. I think in some respects, that's what Senator Claxton was pointing out. And that was that we need to know whose interest it is to know these things. And is it a municipal interest? Is it a property owner interest? Is it a state interest? Who benefits from getting it right? So I think we have to figure that one out too. Ms. Jakes. You're on mute, ma'am.
Okay, so I
Thanks.
want to share like how we went about addressing to give you an idea of the scope and time of a similar kind of project would take. So what we originally sent out was maps that largely had public roads on them. And we asked towns to go through town and sketch in all the different roads that they had in addition, any driveway with two or more. And then, put the names on the maps. Well, there were other things they had to do for us too. It took us probably 15 years to do that at the state level with the voluntary cooperation of the towns. And they didn't have to do any legal research. But it was a huge project. And this isn't going to be done in 1 or 2 years.
Oh, thank you. Mr. Coughlin.
Yeah, I want to add to Maria and Rebecca, as important as this subject is on discontinuance and abandonment, one thing I'm always asking towns when I'm meeting with the face-to-face before we do a review is, do you have a list of all your roads A to Z and what their legal right-of-way widths are? In other words, if you got to ditch a road or cut a tree or rock wall's a problem, how wide are your right-of-ways? And the most common answer I get to that is, no, we don't have that, but we should, because otherwise you don't know if the tree or the ditch is in your right-of-way. And I always encourage them to, and I know several towns have hired interns for the summer. University of Maine system has a great program, and a lot of towns hire them to come in and do just that for the summer, is attempt to come up with an A to Z list by the end of August before they go back to school, which entails digging into lots of stuff. And that's a good way to start, but I'm not sure every student is successful over 3 months to be able to come to the bottom of that. But legal right-of-way widths is a huge challenge in many towns, unless someone like a code enforcement officer or a road commissioner has actually taken the time, a lot of time, to try to dig into that. So I just wanted to add that in. The width is a big research project in itself, let alone the legal status.
Thank you very much. Senator Claxton.
How would it work if we tied the need to do the research to a town's request to discontinue obligations? So how about if it was if the town was advocating for removing some of its obligations, wouldn't we at a minimum want to make sure we completely understood the rights and obligations and history of that road? And that would allowing some interest, because towns clearly want to decrease the amount of road they're maintaining if possible. Would that be an incentive that we could build on to get some of this information for specific instances?
Okay. Ms. Graham, any thoughts?
Thank you for that question, Senator Claxton. I guess my question would be, the roads that are being discontinued now are well settled. Their legal status has already been determined, which is how the discontinued process has started. And they also have the ability to discontinue that easement. So I don't know that you would get more information from adding that requirement. I think the problem with a lot of these roads, and a problem I know that Ms. Manter has experienced, is not the road situation forward and going forward, it's the road situation historically, and the way in which that has been constructed historically. And we can't really roll back all of that process, but we also need a lot more now to uncover that history than we do when we're just in the current discontinuance process, which doesn't seem to be happening very often from what I understand. And I think there's probably less problems because we have that robust process that's now already in statute going forward. And so I don't know how to solve those historic issues, which I think is consistently what this committee ends up hearing about, is that historic issue piece.
Right. So what I'm hearing is most towns really don't know if they have public easements on some of the ways that are within their community. Obviously, there are certain ones that municipalities will know about because they're used regularly by the public. So you know about that. But then there are others that they don't know about. And those are the ones that we're trying to determine how best to handle those roads going forward. Yes, no, maybe. Ms. Manter?
Yes, I can partially answer that. I think what often happens with the question of whether or not a road is a public easement is that when someone moves in onto one of these roads with the understanding perhaps that it's a discontinued road and that they're not going to get any town maintenance, they often are not aware that there's any public easement. But once they've made the road passable and it looks inviting, that's when people start using it. And then when they start to object to the public using it, it comes out that, oh, well, we looked it up and lo and behold, this is a public easement. So that's when it really blows up as a problem. But another thing that goes into the history of these roads is that Ms. Graham said that prior to 1976, roads were automatically taken in fee simple. And I think she's got that backwards because Title 23, Section 3023 says that after December 31st, 1976, roads will be taken in fee simple. And before that, often they were not taken in fee simple. And that's where a big part of the problem is, that they were just taken as easements over the ground, and the land underneath the road still belongs to the abutting property owners. So then the question becomes, if you discontinue that easement over the road, does it revert to the abutting property owners, which would landlock other parcels? And that's why they came up with the idea of making it a public easement, so that there would still be access over it. But as I said, one thing that's beginning to come out now is that sometimes there were private easements or private rights of property access that existed before it became a public road. And those shouldn't be extinguished when the public road is extinguished. So as you say, the history going backwards is a lot of the problem, more than what's happening going forward.
Thank you. Mr. Doak, welcome to the conversation. You can
Thank you, Madam
introduce yourself and then.
Yes. Thank you, Madam Chair. I'm Tom Doak. I'm the Executive Director of the Maine Woodland Owners, and this has been an issue that we've been involved with for years, and we've actually brought several of the pieces of legislation to you that you've worked diligently through in the past. And so thank you for all the good work you've done on this incredibly complicated issue. On this matter, I have some thoughts on some of the other things that we'll talk about, but on this matter, we probably don't have to solve every single road situation in the state of Maine. There are a number of these situations that are working okay, and landowners have worked something out, or there's not a conflict. It's where the real conflicts, if there's a way to prioritize or to incentivize the resolution of some of these more difficult situations, you probably could make some headway. I understand it's a huge undertaking to figure out the status of every single old road in the state of Maine. But there are a number of situations that, and you've heard them because people come to you and say, look at what's going on. I don't think it's just that the town may not know, the town may be in error about its determination as well. So from a landowner point of view, you could have a town says, we don't know, or they'll claim a particular situation, which is not necessarily correct. And I have seen that happen as well. And I'm not blaming the municipality. They're simply saying, well, that's what we think. And so that's it. So there are some situations that if you could figure out a way to help, and kind of feeding off Senator Claxton's thought about creating an incentive to solve some of the most difficult situations as you go forward, there'd be some progress at least.
Thank you very much. Lynn Caswell.
Thank you, Madam Chair. I have a portion of my discussion that I had at the end that might be relevant here. Do you mind if I take about 5 minutes and share what I was going to share later?
Oh, please do. Thank you.
So the idea of a process, at the last meeting, a few of you committee members mentioned a process, and I went back and tried to think of what that would look like. So what I came up with were questions. And the way I looked at this, and again, I was going to share this with you as a jumping off point, perhaps to stir some further discussion. I started to look at it, I think, from the back end, which was if a property owner on a discontinued road has an issue, is there a process for that? Should there be another process for them? And what should that look like? And so that's what I focused on. Should there be a formalized process? Because I think there actually may already be a process in that property owners can go to a municipality and ask that the easement be discontinued. So there is that home rule authority. And so I may be describing a process that does not need to be codified in statute. But is there something about the existing process that could be beefed up? Whether it's, clarifying that if the property owners have private easements or are willing to give private easements, so there is no need for the public easement to allow them access. That's a subgroup. And if they went to a town and said, we all have our private easements, if the only reason you have the public easement is so we can get to our houses, you don't need it anymore. And so that may solve a problem. And I see some people smiling, so I may be, and as I said, these are ideas to solicit conversations. So I guess I can stop there and just say that I had been thinking of the situation, not from creating a map, though I do have information on the Vermont model of a roadway, but from what tools do those property owners need, and what do municipalities need from them so that there's not a flood? Because of course you need to prevent, I would think, let me rephrase that. You may want to think it's important to prevent a flood of these requests to municipalities. And the other thing that hasn't been raised is if the municipality does want to keep a full-blown public easement for every type of recreational use, should that change the equation of responsibility? So that's the end of that was my last item, so you can check it off your list on what I was going to share.
Right. So a municipality's obligation under a public easement is amorphous and it's not necessarily spelled out. Are they required to plow the road, throw gravel in potholes, or anything along those lines?
No, they are not obligated to do any of that.
Okay.
Yeah, no, there's no obligation on their part. And that's what 1513 actually proposed to change. For all public easements, there would be an obligation. What a process might do is narrow down. If a municipality wants a full-blown public easement that allows all kinds of use, and that use causes damage, so that's a smaller world than, so that was kind of what I was trying to do, is try and figure out, is there a process that narrows the problem to a bite size? And I can't say I was successful. I just know that that's what I was trying to, when the idea of process was raised by members of the subcommittee.
Thank you. Ms. Manter.
Yes, and our intent in proposing this bill was to narrow it down. It does not apply to all public easements. It only applies to public easements where there is a residence that's being taxed as a residence. And that's a big part of the problem, where somebody moves in onto one of these roads, renovates an old farmhouse that was there, or builds a new house, and all of a sudden their taxes go way up, and yet they're getting no services. And unless they maintain that road themselves, they can't get out to take advantage of any of the other town services. And if that road is also being used as a public easement or recreational easement, then other people are tearing up that road faster than that person can keep up with the maintenance. So it's that conflict between a residence that's being taxed as a residence and the use of the road by the public, and forcing that maintenance obligation onto the private landowner who needs that for access to their house. So I think that does narrow it down quite a bit, because most of these public easements do not have people living on them. As I said, last I knew in Fayette, there are 21 public easements, and I only know of 2 that have people living on them. So that does narrow it down considerably.
Okay, thank you. Mr. Doak, your hand was up. Are you all set? You're on mute, sir. You're on mute, sir.
Yep,
You're okay?
Thank you. I had a similar thought, just because there's two, the original purpose of these public easements were really to prevent landlocking and help people get to their property. That was the original intention. And we have compounded it. I think it's compounded by the fact that the public gets to use these somewhat unrestricted, to be honest with you. And then we have new uses going onto these properties. And again, the landowner is responsible. The original you can't create a public easement. I think it's good to remember, you can't create a public easement under I think it's the Constitution. I don't know if it's a statute or Constitution, but except for motor vehicle and pedestrian traffic. You last session changed it to say new public easements are restricted to motor vehicles and pedestrian traffic. Now there's this group in the middle now that there is no restriction, and one of the big issues is people that the public recreation, the people that don't have to use the road, are not regulated in any way. And so you have a situation where the people that have to use it are maintaining it basically for the public. And that's really one of the big conflicts. I don't think you're going to solve all the problems with people that have to use it. Some of it's just being good neighbors, and sometimes they're just going to have to work this out, to be honest with you. And sometimes it's their responsibility to work it out. In many cases, it does. The frustration is it isn't clear what you can do on a public easement or if there are any restrictions. And then the liability and obligation is entirely pushed onto the landowner. And whether it's, a municipality can't be sued for allowing a use, but can the landowner who now owns the land be sued for the use? Because the municipality is protected by the tort law, but not a landowner. Those are the kind of problems that you have. That's the real friction point as I see it.
Thank you, sir. Ms. Graham.
Thank you, Representative Matlack. I provided Lynn a long time ago some information regarding that. The landowner is not responsible for injuries or damage caused to people that are using that public easement over that owned property. That's in statute already. And there are already existing mechanisms to address damage to those easements, and they haven't been tested. This committee worked really hard on making that go forward. And it is the same burden that applies to municipalities. They have to do and follow the same processes in order to actually engage with that mechanism to get those reparations as that landowner would. Also, one of the list of issues, the biggest list of issues, were the uncooperative neighbor piece, which was the piece that required municipalities to maintain that. So there is now this obligation on municipalities to provide individuals with the information that they can form a road association. However, if not everyone on that road wants to form that, then they're the ones that are holding the easement that allows everyone else to that unruly neighbor. And there have been anecdotal cases that municipalities have responded to that specifically deal with this kind of kingdom approach that one neighbor will end up assuming over that road that restricts others, including the use for timber activity, which tends to be the biggest complaint that municipalities hear. So I would love to actually drill down and get some hardcore examples of where the current law and the way that it's written can't address some of the issues that Mr. Doak just raised, because I do think there's mechanisms, and maybe there needs to be, a public education campaign about it, but we actually need the real world examples, because I think that all of this stuff that you just mentioned already has existing mechanisms within law and just needs to roll forward. The other piece is why that it has been maintained. So the access to great ponds, the access to tidal waters, those are things that can't roll back from. They're public trust doctrine pieces. And cemeteries. Cemeteries are a big issue. And even in larger communities, Freeport, for example, you have a private owner that comes in and now has cut off access, which has been historic access. That family who no longer lived in that community needed to actually go through and use the municipal public easement over that property to get to their what was historic family grounds from a large corporate entity that was blocking off that access and didn't want that access in there. So I think that we need to recognize that there are as many uses for these public easements that stop issues as they may create issues. So it would be good to take Senator Claxton up on that idea of applying it on a case-by-case basis and see how something might work out and what isn't available currently.
Thank you. Representative Toole.
Thank you, Madam Chair. I want to also thank everyone has provided really good comments here and thoughts, and it just goes to show how complicated this is. But in particular, Miss Rebecca Graham really did a great job lying just when you think you have something that may work. There's good reason there is law in place that we have done that hasn't fully had a chance to play out. But I do think, and I mentioned this morning on the phone to Representative Matlack about how to proceed, because I think we all do want to proceed.
Oh, what a relief that is. So fast.
And what I was thinking about this morning was the idea, we have another bill in state and local to do with setting up a commission on cemeteries. It's dealing with all of the issues related to, or a lot of the issues related to cemeteries and who's responsible for what, access, all those type of issues that come up every year. And the bill proposes to set up this commission. We're in the final stages of putting it together, hopefully, and hopefully we can get it passed this coming session so that we're not back at that spot all over again every year. I would like to think we could do something similar, maybe with the abandoned and discontinued roads, to have a commission that meets quarterly, whether it be 11 or 9 or 13 members with stakeholders that can propose legislation, that can vet legislation, can look at specific examples. We've got Ms. Manter here with a wealth of knowledge. We've got Ms. Graham with a wealth of knowledge. We've got all kinds of folks across the board. And maybe that is, I know that's inadequate in some ways, but if we want to get a long-term solution to this whole topic, we need to have people that are not here for just 2 years or 8 years and then gone. And I'm thinking that might be a solution. So I don't know what people think about that, but maybe that's a starting point going forward given that we have done legislation the last 2 sessions or 2 cycles to try to address some issues, but with a commission to kind of build on that and flesh out some of these things like public easements and all of the issues. The inventory is not insignificant, but all of this stuff, I would say. So I guess I've run on long enough, but that's kind of where I'm thinking. My head, like Senator Claxton's, is spinning, I'll be honest.
Thank you, Mr. Toole. Representative Copeland. You're on mute, ma'am.
Thank you, sorry.
No worries.
Thank you. I'm going to just tell you what I'm thinking and where I want to weigh in. I agree with Senator Claxton that we need to keep this simple. Hearing that a lot of this research is like very expensive, time consuming, and the state of Maine, honestly, I can't vote for something that will just spend money for, some situations that come up from time to time that have civil remedies. I know we're talking about paying taxes and not getting services, but the MMA's information that they provided in our subcommittee package says that the obligation to pay taxes is not contingent on the services received. And the MMA also put out information that said the 127th legislature enacted 2 separate laws to allow for civil and criminal actions against persons who damage public easements in an effort to address the concerns expressed by the Manters. So we're trying it, and I don't think it's going to be perfect. And I am very happy that Ms. Graham has mentioned that she'll kick it around and see what, her collaboration of 70, members can come up with, if anything. And I agree with Representative Toole that we need to continue meeting on this. I propose that we continue this. I don't know, Madam Chair, what the mechanisms are, but to continue this conversation and to continue to bring in people who have some real input. I appreciate Ms. Jakes and Mr. Coughlin, and that certainly their employees don't have time for this project, and I don't think it's a good way to spend taxpayer money. I don't think the volume is there enough. but clearly I don't have all the data, so I don't know. But the issues that Mr. Doak raised, I agree that those are real issues. And, you know, I don't know where to go from here, but I think having this discussion and continuing on with this discussion is helpful. Thank you.
Thank you. We have permission to meet 3 times between now and December. So we have one more meeting we can schedule, but also come January, we could continue on our discussions at that point if we cared to. So Mr. Doak, please. You're on mute, sir.
Thank you. Rebecca, I'd be happy to look at the information you sent about liability. I am aware that a landowner, if I don't know if you're talking about environmental liability, but under the environmental laws of Maine, if I as a landowner can prove that I'm not responsible for the violation, I can be exempt from the fines, but I'm still obligated to fix the problems. I don't know of any other thing that would reduce that liability. And so in the situation, I believe the landowner in this case, the owner of the property is the landowner, so they are on the hook for the cost of any repairs. And there's nothing that protects them from personal liability. I don't believe in statute. If there was, maybe we should look at that and make it clear that landowners have no obligation on those. I do have a couple thoughts of areas that you might want to explore. I think I may have mentioned last time, and I don't know how it works legally, but in many municipalities, you have situations where residents or property owners accessing municipal property pay a different rate or get a pass or don't get a pass or something like that versus people that are just recreating or want to use the town beach and things. And I don't know if there's some way to make some distinction there that would be helpful to people that own land. And then I think the other issue that I hope the committee at some point will address is are there any limitations on the use of these public easements by the public? And what exists in statute or what should exist, or may a municipality authorize anything they want to occur? There are 4 times you have to have affirmative permission in the state of Maine to use somebody's land: trapping, putting a game camera up, tree stands, and riding an ATV. By statute, all 4 require the permission of the landowner. We do have a situation, and we do have situations where ATVs are being granted permission across these lands. And an interpretation of the statute on one statute, but the other statute says you must have the permission of the landowner or lessee, period. Those are the only 2. So you have a problem here of what is allowed. And if you could examine that issue and at least clarify it wherever it goes, clarify what uses are allowed, because we're going to invent more uses in the future. And we didn't have ATVs when this law went into effect. And, we're going to have something else here pretty soon. There's some amazing things coming. So I would ask that you examine that issue a little bit at some point.
Yeah, thank you. Mrs. Manter, please.
Yes, I agree with several things that have been said here. I also would like to know what protection the landowner has against liability if someone is injured using a road that they have maintained. I'm not aware of that being in the law anyplace, and I would like to see if it is in there somewhere. As far as the 2 statutes that were passed recently, giving the landowner some protection if there's damage to a public easement, those were very good efforts, but where Ms. Graham said that they were not tested, I can think just off the top of my head of half a dozen cases that I've been aware of just since those laws were passed, where people have come to me saying, what can we do? Somebody has damaged this road, and I've said, it's a public easement. You have these 2 laws you can use. And they have gone to law enforcement. Some of them have gone to multiple different law enforcement agencies. They've gone to county sheriffs. They've gone to state police. They've gone to Inland Fisheries and Wildlife, Warden Service. And the answer that they get every time is sorry, there's nothing we can do about it, in spite of the law. And I've told them, have the law in your hand, show it to the law enforcement officer, see if they will enforce this for you. And they're saying, no, there's nothing we can do. I do like Ms. Graham's suggestion about education. And one thing that I have suggested to these people is there are companies that you can go to that will print custom signs for you. Get custom signs printed that say, warning, it is a Class E crime to damage a public easement with a motor vehicle. And if they put that up, then at least people who use the road are going to be aware that maybe they shouldn't be, or maybe they should be careful how they use this road because there could be consequences. But a lot of the problem is that these people are hard to catch, and you have to prove who did the damage, how much damage they did. You have to prove that the damage was their fault and not a weather situation. There was one circumstance we had on our road where during mud season of one year, we were invited to go and house sit for someone. We said, good, we'll be off the road. We can just let the mud settle. Things will settle out and it'll be fine. I still had a horse at that time that I had to take care of. So we went over in the morning, walked in, fed the horse, walked out again. It rained hard all day. And when we returned in the evening, we found that there was a single set of tire tracks going right smack up the middle of the road, all the way past our house to the point where the road became impassable. And then the person decided, oh, we shouldn't go any further, or we can't go any further. And they turned around and drove right back out, the same two ruts all the way out. And the result was that all that rainwater couldn't get off of the road surface. It was channeled right down those two ruts. And for about a quarter of a mile, the water ran straight down the road and gained such volume that when it hit the culvert at the entrance to the road, it blew the culvert out. And we couldn't get back within half a mile of our house when we returned that evening. So how do you prove it? They came while nobody was there, nobody saw them. And how much of the damage did they do? How much was done by the rain? These things are so hard to prove that those laws have been pretty much unenforceable. Unless you have game cameras out, unless you have pictures of the condition of the road before the person drove through, so that you can compare with the pictures after the person drove through, and you have a picture of the person driving through, it's very hard to prove anything that you could take to court or that you could find them guilty of. So I think they're a good start. I think the intention was great, but the problem is, how do you enforce these things? And again, I think education would be a big part of it, not only educating the public, but also educating the law enforcement agencies as to maybe what they can do to help in these situations. Also, as far as the use for access to great ponds, my understanding was that the access to great ponds was to be by foot over unimproved land, and a road is not unimproved land. As far as ATV use, again, the restriction that was put on the new version of the abandonment law that's I think either has just gone into effect or is about to go into effect, saying that the use is to be by foot or motor vehicle, that would exclude ATVs. They're excluded from the definition of motor vehicle. But if we go back to the case of Town of Fayette versus Mantor, don't know how I know about that one. Footnote 1 says that the public has an unfettered right of access over a public easement, but that the public is not responsible for providing any maintenance. And as soon as that went through, we kind of had an explosion of complaints that these roads are getting used for everything. Unfettered means there's no holds barred. You can use it by ATV, you can use it by snowmobile, you can use it to skid your logs down it. And so certainly that restriction on the abandonment public easements is a good start, but that doesn't address all the public easements that we have due to previous previous abandonments or previous discontinuances, and it still isn't in the discontinuance law. So those are some things that maybe could be addressed. That would be small solutions to parts of the problem. I think that was. I think I've covered all the points that I was hoping to catch up on, and thank you for your patience.
Okay, thank you, Ms. Mantor. Representative Copeland?
Thank you, Madam Chair. I'm not a lawyer. I don't know what the Maine Tort Claims Act is all about. I'm wondering if our analyst can help with that. Is it just about municipal immunity, or does it go further into that? That's a question I'd like to know about. In terms of putting signs up, I would just caution that, make sure that they're legal signs and that the municipality allows them and whatever. Now, what about, I get it that in the instant matter, the situation is that they have an alternative way to get out of their property. It's just not convenient. And I wonder if that's a way that can be, brought up or whatever in that situation. But I is the access for landlocked parcels if it's the only tool to continue access? So that's a question. If our analysts can dive into that. I'm getting that from the Maine Municipal's information that they put out. The one about the Maine Tort Claims Act comes off of her document, MMA legal notes that were part of today's package.
Okay, thank you. Thank you. Lynn?
Thank you, Madam Chair. I just want to, and this may respond to part of what Representative Copeland just asked. I want to clarify the landowner liability and what Rebecca was referencing and Tom Doak. There is, and for Rebecca Manter, it's Title 14, Section 159A. So that section provides liability protection to landowners. Let's see, an owner, lessee, manager, holder of an easement does not have a duty of care to keep the premises safe for entry or use by others for recreational activities, and recreational activities are defined to include 1, 2, 3, 4, 5 lines, 6. So that statute says that the landowner is not liable if someone is injured or their property is injured when they are on recreating, which is climbing, hiking, trapping, fishing, boating, sailing, dog sledding, ATVing. So that statute is about to landowners' liability for personal injury or property damage. What Mr. Doak was talking about is another statute about environmental damage. And that statute does put liability on the landowner unless they can show someone else did it. If there is environmental damage, that landowner has an obligation to repair. And so, for example, if ATV use destroys a bridge over a stream, and I'm getting a little bit out of my depth on, because I'm not an environmental lawyer, but that's the type of responsibility that Mr. Doak is talking about. The statute says if you can show someone else did it, landowner, you're not on the hook. But generally, the recreating, I think that's the distinction. And I'm going to say there may be more nuances than that, but that's the distinction between what Ms. Graham was talking about and Mr. Doak. So they were both being accurate, but talking about a little different things. And the Maine Tort Claims Act does apply to units of government. It does not provide any protection for landowners, if that was what you were asking about, Representative Copeland.
Thank you. Mr. Doak?
Thank you, Madam Chair. One other, Lynn did a nice job of explaining that. The other part about the liability law, it doesn't mean you won't be sued. In fact, you can be sued. There's great protection for sure, but you can be sued. The court, again, the statute does say that if you win your case, your costs have to be paid by the person suing you if they have money to pay. But the standard of practice in the industry, when you grant permission for recreational use on private land, not a public easement, not a discontinued abandoned road, is you would have a written agreement, and you would have that the person, the club, typically a club, you are requiring them to have liability insurance, because that law, the law is really good, but most landowners will require that and have the ability to do that before they grant permission. The state of Maine trail systems actually, if you make an arrangement with the state of Maine on a trail system on private land, the state of Maine carries an insurance policy that covers your liability because they recognize the potential of a liability to the landowner for that recreational use. So they actually provide an insurance policy to protect the landowner who agrees to allow the use. So there's liability there. You're not absolved. They're very good law, but again, if this was a public road, you wouldn't have that. But once it becomes the public easement, now the landowner carries additional liability that is pushed onto them. Thank you.
Thank you. Ms. Graham?
Thank you, Representative Malik. I just wanted to clarify a couple of points as well, that ATV use requires municipalities can't regulate anything to do with ATV use or define use on a public easement or a public trail unless they positively post that. They have to have a local process which involves their community, and then they have to positively post that activity on those roadways. And with regard to the Great Ponds, 20 years is the common law approach. So if there is a road that has been used years to access a great pond, that exists, that easement exists automatically. And with regard to enforcement, the landowners that Ms. Manager were talking about, they have to prove, they have to go after, and law enforcement doesn't get involved. That's the same thing that municipalities have to do. It's identical to that same whole process. Law enforcement doesn't go out and grab folks that damage our roads. If there's some sort of egregious accident as a result, that might be swept up. There might be a summons in there. But in order for a municipality to be made whole, they have to sue someone, regardless of whether or not that damage is a crime at the time that it does it. It is a civil process. And we have the ability to bond for timber activity, which damages roads. Maybe that's something that can be explored for private owners. Maybe we hear quite frequently that timber activities at the other end of an easement are a problem, and that damage to that road is a problem, as Ms. Manter has said before. Maybe there needs to be some sort of authority to allow private folks to be able to bond for that activity, so that the damage is part of the repair that happens for that activity. But essentially, they currently now, thanks to those changes, have the identical tools that municipalities have to pursue someone.
Thank you. Could you clarify something for me? I may have missed it. You were talking about ATVs and a municipality's ability to allow or disallow. ATVs are prohibited unless given permission. Is that correct?
Correct. So the only way that a municipality can regulate ATV usage, because that is wholly the purview of the state, they have the ability to determine that they have operation on a public way, okay, which would include a public easement. But usually there is a robust process over a public easement that involves those particular members of that roadway. But they have to have a public hearing. They have to publish where they are determining the operation is going to be allowed, and then they have to post that. So there has to be signs saying this is a public way, or ATVs are allowed on this public way.
Thank you. Ms. Manter?
Yes, I think the suggestion of allowing the landowner to require a bond of a logging operation, I think that's an excellent idea if there could be a way to do that. Right now, the landowner really has no recourse against another landowner using the road for his purposes. And if that purpose happens to be logging, there's nothing currently that I know of that can assure that other landowner will use the road responsibly. The other thing that I wanted to address is that there may be limited landowner liability for recreational use, but a lot of the uses that we see on these roads, particularly when it comes to a discontinued road that was once a through road, often those roads still appear on GPS. So, for example, on our road, we get a lot of people that drive in just looking for a shortcut across town. They're not recreational users, they're just travelers trying to get from one point to another. And they get just beyond our house and find out that the road really isn't get the kind of road they want to travel beyond our house, and they turn around and get out again. So we get 2 trips instead of just 1. And then we also get a lot of delivery trucks trying to deliver things to people who live on the other end of the road. And they come in using our end of the road and again, find out they can't get through and they turn around and go out again. And that again is not a recreational use, and all that traffic adds up.
Thank you. Mr. Doak?
Thank you, Madam Chair. I think there is an area Rebecca mentioned on the ATVs. There is an absolute dispute on this issue. For example, Title 12, 13, 157A, permission required. It is the requirement of a person to get permission from a landowner or lessee, period, providing an ATV. Most people don't know that there is an exemption in statute for the state has prevents the municipality from regulating ATVs, except on land they own or where there's a public easement. It doesn't say public easement on a discontinued abandoned road. It says, I believe it says public easement. So the question then, if that is the interpretation of the statute that any public easement anywhere you can, the town can regulate, or does that statute trump the requirement that you have to have the permission of a landowner in order to ride an ATV? Those are some of the conflicts that we have. Some of the arguments we have people using those roads that the landowners don't believe that they have the right, and the municipalities are telling the towns they do. And so you could clarify it one way or the other. It would be helpful to avoid some of the problems that we're having.
Thank you. Ms. Graham?
Sorry, that was a legacy hand.
No worries. What I'm hearing a lot of this about, excuse me, Representative Toole, did you raise your hand?
Yes, I guess I did. I guess I would respond and say some of these conflicts are legal conflicts, that some of this really should be resolved in court. Some of it should be resolved in the legislature. The overall long-term policy maybe, but some of these issues is the interpretation of what law takes precedence over what. I feel as if that's a question for the courts and not so much the legislature. But at the same time, I do think the long-term issues around easements and access and all of that that's why I suggested a commission that we set up with different stakeholders to make independent recommendations, independent of the legislature, that can vet each situation and come back to each year with knowledgeable proposals that are well developed, well thought out, and presented to the legislature, similar to what the Cemetery Commission did. That's why I suggested that and failing that, I guess I would go to something one of our former chairs once suggested, and that was that all of the stakeholders get together and see where they can come to agreement and bring something back to us for the third meeting, because otherwise we run the risk of going around in circles.
Yeah, thank you. My question was mostly along the lines of clarifying what a public easement is, because there's such a variety, whether or not things are required or allowed on certain public easements, whether or not ATVs, whether or not commercial use is a public easement. Is it public for everybody? As Ms. Manter's, I guess, a court decision stated that public easement means anybody can use the road at any time, or is there a limitation, or should there be limitations on what public easements are? And if a municipality is going to keep a public easement on property for the benefit of some of the folks, abutters who cannot agree or something along those lines, is there a way to confine the the parameters of that public easement so that it's narrowly tailored to the interests at hand, rather than a public easement means everybody can use that road at any time, commercial or private. Lynn Caswell?
I'm just going to make a few comments. I'm not going to be able to answer your question fully, but just a little bit of information. So the unfettered access was a court decision, and that's based on the fact that public easement is not well defined in statute. And so the court steps in and defines. And prior subcommittees have looked into, is a solution coming up with a definition? And generally the decision is that would be, as Senator Claxton talks about, that's just going to be digging a different hole and will most likely cause more problems. So changing the definition in statute is not really a solution. So that's the first thing. It's not defined as far as those existing public easements. What I haven't heard discussed a lot, or maybe this is more for someone like MMA, is our municipalities, do they believe they have the authority to restrict public easements? I think that the law allows them to do that and restrict it in ways such as people can use the public easement for walking, talking, chewing gum. What a municipality can't do is restrict it to the 5 people who live on the road. They can, my view of the law is they can restrict, but they have to, it has to kind of be even-handed, like the example where Mr. Doak talked about the town beach. You know, you can limit it, but it has to be in an even-handed manner. You can't be just benefiting a specific private individuals. And hopefully that was more helpful than not.
Yeah. Ms. Graham.
Thank you, Representative Matlack. Lynn, just to kind of answer a piece of that, I know that there have been issues in the past with municipalities accepting public easements, particularly within the setting of subdivisions, for restricted purpose. It wasn't clearly defined in law. And there are some communities in Southern Maine that have dealt with that. So there was a hope to take what was, or, you know, rather than accept the road, if they accept the road, then they have to allow all traffic. Accepting an easement on what was a paper road for the purpose of recreation seemed to be at odds. And we dealt with that within Transportation Committee. So that was actually last session. And there might be a lot of stuff that Sam Prowler might be able to pull up a bunch of stuff regarding that. But I know that that's probably, you're probably correct that municipalities don't think they have the authority. And I think, at least for paper roads discussion, I think that's what came out of that as well.
Thank you. Mr. Doak.
Madam Chair, I do think your suggestion has some good merit to look at. I'm also aware of, you know, not wanting to create another hole today, and we don't want that. And I always said, let's stop making things worse. But I do think there's some area to investigate there, whether it's to say, you know, this use, this use happens, but if you're going to allow this use, there's some additional responsibility for whoever allows that use, or something that might be helpful in this situation to just kind of get the friction down. So I have some thoughts, and I do think that is an area worth discussing without, nobody wants to make this any more complicated than it is, but how do we keep the problems? Nobody anticipated these problems 30 years ago when they put this in. It was just keep people from getting landlocked. Now failure to think ahead of what's coming has got us into this situation. So what can we avoid that's going to happen in the future, if, you know, by being thoughtful about it. So frankly, I liked your area of exploring.
Thank you. Representative Downs, your experience working for a municipality for many years probably gives you more insight into this than some of the rest of us. Do you have any thoughts on where we are today?
No, it's been well covered. Everybody's covered it very well. I haven't had all that much experience in the municipality because we have what we call in our area a book of roads and when they've been abandoned, the dates and everything. And we've never had any issues come up about this. So this is quite interesting and all new to me. So.
Okay. Thank you. All right. So I think we're not going to come to a resolution today. Yes. And I think we are at the end of what we can discuss in this matter. I think we've raised some issues, looked at, heard different concerns, heard from various perspectives how circular this is. And I'm wondering about, there was a suggestion of perhaps getting stakeholders together to discuss and with much more knowledge, insight, history than we have here on the committee, and discussing and perhaps bringing back to us an idea of what might be a resolution that would be effective, that would actually enhance what's being done in the municipalities rather than burdening them, assist landowners in being able to figure out what's going to be done, and give them a little bit of assistance in trying to determine how and when the road that runs alongside their property is allowed to be used, and what the limitations there are also. Representative Toole?
Yeah, I appreciate that. I think that if we're going to, in the third meeting, if we're going to make progress, we have to have something that all the parties, MMA, Ms. Manter, Mr. Doak, even the folks from DOT and E911, even though they're on the periphery of it, folks that they all can see as workable. I will say that if we're going to go down the road of public easements and addressing what that looks like, we should really consider having Sportsmen's Alliance involved, because the last thing anyone really wants to do is have 500 sportsmen showing up in committee upset at something that we may have thought was a great solution for some, and all of a sudden the sportsmen, the ATVers, those folks, everybody that uses outdoor recreation. I think Sportsmen's Alliance needs to be a part of the discussion as well with that. So if that's going to be the direction the stakeholder meeting goes, but I would say when we come back, the stakeholders should have 2 or 3 things for the legislators on the subcommittee to haggle over and say, yeah, this is something we could support or not, or does it trigger a mandate? Is it going to have a fiscal note? Stuff like that. Go through all of those boxes, because otherwise it's going to be a lot longer. And I'm fine with continuing, but I think we need to have that structure and direction to it.
Thank you for your input. Can we ask Ms. Graham, Mr. Doak, Mr. Coughlin, and Ms. Manter to discuss this issue and come back to us with suggestions or ideas of either how to solve it, or how, Representative Toole?
Yeah, I would, with that, I would ask that, I think if Lynn would be willing to facilitate it and kind of, I don't want to say referee, but sort of keep folks on track and keep people focused. And I think that would help us. I think that would help us when everybody does come back, lend some structure to it.
Thank you. Mr. Doak?
Madam Chair, I'm happy to be involved in that. A couple of the bills that you've been able to pass in the past couple of years. That was the direction. We got a clear message from the committee, said, you go get together and figure it out and come back with, either recommendations or, here's where you agree, here's where you disagree, here's two options, pick one. And we've had some success with that. I'm committed to helping with any group to see if we make some progress. And I sent Rebecca a quick note saying I'm happy to work directly with her. So yes, I'd be happy to participate.
Thank you. Ms. Manter?
Yes, I've always said that the only way we were going to solve these problems was to find solutions that work for everybody. We can't find a solution that works for one and makes it worse for somebody else. So
Right.
I've always been interested in looking at both sides of the issue and saying, how can we keep the costs down for municipalities? How can we make this easier? And yet, how do we also preserve the private landowner access without infringing on either private rights or public rights in the process? So I'd certainly be willing to work together with the other parties.
Thank you very much. That being said, I appreciate you folks in accepting our invitation to please work on this and come back to us with some suggestions about how we might resolve these issues. It's quite complicated, and I look forward to hearing from you and meeting again, perhaps. Is it in November that we would be meeting, Lynn, or is it before December, or?
We do not have our last meeting scheduled.
Okay.
But we do need to have, usually the subcommittees have their work finished before the second session starts. So,
okay.
And the holidays are immediately preceding. So usually committees meet again in November.
Okay.
So
okay. Perhaps a poll later on.
Yes.
Representative Copeland?
Thank you, Madam Chair. And I know that you're trying to wrap it up, but I have one thought. When they were talking about how people destroy the road and they can't have access, is there, and I know that it won't work for every situation, depends on the width of the road and lots of things about the road, but could there be a cordoned off area for the homeowner only to use and still give access to the public and the rest of the easement? I mean, it depends on a lot of things, but I don't know. I just want to throw that out there.
Okay, thank you. Representative Toole, your hand's up.
Yes, I guess I would say, I think it would be good to give the various stakeholders a deadline of, say, I don't know, do we want to say November 15th or?
Is 2 weeks sufficient?
Oh, is it 2 weeks? All right.
It's like 2.5 weeks out, yeah.
All right, say November 30th.
Okay.
Give them
Is that
a
better?
month to figure something out, and then once we know where they're at, which we'll know after Thanksgiving, then we could schedule our next meeting.
Right, for either in December or perhaps in January when we reconvene.
So once we're back in session, I don't think we have a limit on the number of subcommittee meetings.
Right.
Beyond what
Okay.
we're willing to deal with, so.
Yes. So if the subcommittee is finished with their work earlier than the end of November, because I don't want to hamstring you by saying, oh, 2 weeks. But if you're finished before that, you can notify the committee and we can meet again at an appropriate time. Lynn?
So I just want to make sure I understand what the next steps are. So I will help organize the interested parties, which is MMA, Maine Woodland Owners, Maine Roadways, and the Sportsman Alliance, and Maine DOT?
I wasn't sure about Sportsman's Alliance as much as I was Maine DOT and E911.
Okay.
I know that Representative Toole was talking about them, but I would like to finish the work that we're heading down on. We can allow them to come in and chat with us at our next meeting, but I don't know about adding them to the list of folks when we've already been working on this for a couple of meetings, and that's just my 2 cents. Representative Toole?
Yeah, and I was suggesting them for the simple reason that if we're going to be talking about public easements, which is something that is an issue that they're really, I would believe that they would be very engaged and interested in, that they would want to, but if they do have an opportunity to participate in the next subcommittee meeting and see what the others have come up with, I think that's certainly fair if it goes that direction. But and I would add to it that I think Lynn Caswell definitely should be synthesizing and giving an overview of what comes out, because everybody's going to give where they're coming from, but I think it's important to have that nonpartisan voice presenting where we're at or where the stakeholders feel we're at.
Okay, thank you. All right, Lynn, is that fairly clear now?
It is, and the stakeholder group is going to get its work done by the end of November. I'm just
Thank you.
saying that because they're all online right now.
Okay, thank you very much. Thank you all for participating today. Anything else before we adjourn? Have a lovely windy day tomorrow, and I look forward to seeing you again soon. Bye.